Namaste. Welcome to the Cārvāka podcast. This is Kushal Mehra. So, today we're going to talk about this is such a weird thing that I think these kind of things only happen when secularism comes at crossroads with Islamism, to be very honest. So, there are two parallel stories. One is in St. Rita's public school in Kulam, Palluruthy in Kerala, where this convent school basically decided that they're not going to let hijabs. And basically, it was a universal order about all kinds of religious dress codes. And then the latest rendition, and ये तो मतलब चालू होने के पहले खत्म हो गया. In Goregaon, Mumbai, there was this Vivek Vidyalaya and Junior College where they said they are not going to have hijabs, and that was done. By the way, there was another incident very recently. I think it was in Indore or someplace where the Catholic school said no tilak, vilak, nothing. No, basically no religious symbols are allowed. और एक वो पता नहीं एक लंबा टीका लगा हुआ आदमी जाके ऐसे कैसे करोगे तुम सब कर रहा था. So I wanted to focus on what, see, this leads to two three. Nikhil is going to look at legal issues, but I want to look at the philosophical problem here, that who has the right? Is the educational institute, they have the right as a private institution, or do I have a right to practice my religion wherever I want to, and where do these lines cross and where are the blurry areas? So that's why I wanted to do this. So Nikhil, ये है क्या, हमारी constitutional framework में इसका आंसर क्या है?
It's not a very clear answer also, Kushal. Firstly, I'm just glad to be back. I've been doing too many cricket podcasts. I'm going to be doing law again. Now, 3 years ago, we had the same issue. And if you remember, about 2 years ago, you had done a podcast with me, Amna, and Khalid on the hijab ban, right? And that was in Karnataka. Now, our constitutional framework starts creating certain categories, right? So separate out bans on hijab in secular schools, one category, right? Bans on hijab in Christian schools, second category, right? And they are treated differently under the constitution. That's why I'm making them separate categories. Okay. So essentially speaking, this is an issue that has come up repeatedly. And in my view, until the two judges of the Supreme Court, Justice Gupta and Justice Dhulia, looked at it in the context of Karnataka, it really didn't get very good deep treatment. And actually, it can't get deep treatment, Kushal, because I'll be honest with you, there appears to be a reticence amongst Indian legislation to actually say what it wants to say. Right? They keep going to uniform and saying we are changing the uniform, hijab will not be allowed. So in Karnataka, what was the issue? So the Solicitor General also raised this issue. He said this fact. He said there is a substantial amount of activity qua hijab just prior to this set of conflicts arising. Where does this come from? It comes from the presence of the PFI, which is moving northwards from Kerala into Karnataka. Right? So what you really want to say is that hijab to you is a reflection of extremism as embodied by institutions like PFI. But you don't say that. In your actual order, which is the government order that you pass, you make the banning of hijab into an aspect of unity and progressiveness. Right? So it doesn't actually attack the hijab. It just says having parity is unity. And that is our aspect of fraternity. That is why you get arguments from the other side that say fraternity should really be that kids who are at this age, who are living together, who are studying together, should be exposed to each other's cultures in fullness. Right? And it is very difficult to argue against all of this. I mean, what is correct? Yeah? It just depends on what you give more weight to at one point in time. You can't really say one principle definitely predominates over the other. It is not entirely undiscernible, as happens in the United States, right? That your various religious symbols, you will exercise them every day. I mean, today, to be honest with you, all of this becomes an easier argument for you because you have such a remote and non-existent Jewish population. But if you had a observant Jewish population, that were wearing the yarmulke or various other symbols of Judaism, particularly on a Friday, leaving on a Friday, not attending classes on a Saturday, things like that were happening, then you would not be able to say simply that we are banning religious symbols. Because today, every case that I have seen, the order is we are banning religious symbols because we don't want that religiosity, that express religiosity, to be present within a college. And I find that to be quite a hypocrisy, to be perfectly honest, because that's not really why you're doing it, right? It's a tactical win for you, but it's not really why you're doing it, because I think that's how we understand it, correct? Or am I wrong in that?
I don't know. For me, see, my opposition to the hijab as a dress is very open. I find that dress to be hideous. But
That's
at
what
the
I'm trying to
same
say.
time,
So you will probably say it is a abomination to the progressiveness that you are now trying to inculcate within your education system, right?
yes,
Let's break it down even simpler. 1950 arrives. Let's just take the two largest communities, or let's take any all communities. We had a lot of medievalisms that were a part of our common social behavior. What is the complaint here? One side has had to progress a lot faster. Today, your Hindu Succession Act, your Hindu Marriage Act, etc., only have a label which is Hindu, but there is nothing Hindu about them. The Hindu Marriage Act, the divorce principles are exactly the same as the Special Marriage Act, which is a secular law. There is nothing Hindu about them. All right. There are deviations even in the definitions of Class 1 heirs under the Succession Act, which makes them completely non Hindu. There is an elimination of the HUF. All of these, in my opinion, were choices the state made. And one of the choices you make by doing that is we want more nuclear families. We want more population movement. We want more independence in your actions, right? Different matter that if you choose to be together, it's a different thing. That's okay. Then you pool your resources, pool your money. And if you pool your money and you have records of that, you can always then partition. But an HUF is conceptually dead because you have a deemed partition at the time at which a karta passes away, right? So all this progressivism arrives to one side, and you don't bring the concomitant progressivism to the other side. This was really what the whole complaint is. This is a part of where the right and the left diverge on politics in India. I don't think the left has very good answers on this, other than to keep calling everybody a bigot. And the right has not legislated to the honesty of its own beliefs on this. So let's be crystal clear about that being one of my fundamental critiques on this, because you should have done this. You should have gone and said, as the Supreme Court does in Sabrimala, although that judgment is now under review, that a practice that effectively penalizes women for menstruation is not a modern practice, and we will not protect it. That's what you said, effectively, in Sabrimala. Why can't legislatively you say the same for hijab? Because you don't want to take that debate on. Right? And because there are such poor comprehensions of first order, second order, third order problems here, that you think, yeah, if we do this, and how do we preserve a tilak? How do we preserve a vibhuti? You don't have those problems. Those things are not symbolic of the same thing that a hijab is, or certainly can't be proved to the extent to which a hijab can. I mean, you have Iranian women willing to die to take off a hijab, boss. You have Middle Eastern countries where none of this is mandated for anyone, other than in very, very defined spaces. Very defined spaces. Because everybody gets it. This has to be let go of. But that's not your legislation. So let me go through certain case law. And because we were talking, because when you contacted me, this was in the context of Bombay, I wanted to take a Bombay case law first. Two judges of the Bombay High Court. And then I'll come to the Karnataka controversy and look at it in greater detail. Right? And the
oh
judgment
yeah,
that was,
कर्नाटका में भी 2-3 साल पहले यही तमाशा हुआ था ना पूरा.
was it became a Supreme Court judgment.
Yeah.
There is no other hijab Supreme Court judgment. It is the main hijab Supreme Court judgment, right? And how different the approaches are. So,
Yeah,
I wanted
yeah,
first,
but honestly, Nikhil, before you start, I think this is a case of competitive bigotry.
in what way?
I think the Hindu side is also not opposing it. A lot of the Hindu side is not opposing it out of some constitutionality or some principle. I think it's just competitive bigotry. Islamist bigotry stems from subjugating women and, wrapping it under religious freedom. and a lot of Hindu bigotry and opposition to this stems from Muslim hatred. But behind this, if you ask me, people like me personally, who have no ill will towards any community per se, but have a deep seated hatred for the hijab, because it symbolizes everything that is wrong in
Yeah,
our
so it
society.
symbolizes extremism. If you say that, then you can't say this is bigotry on one side. All right. If I go and say, or if a Muslim stands up and says caste is abhorrent, that's not bigotry towards a Hindu. There are
No,
sounds.
but you didn't let me complete. But at the same time, you have to jostle between the right to wear what you want to wear, even if what you're trying to wear is stupid.
Stupid is so, and you have spaces for that.
Yeah.
Therefore, the scope of
So
what you
it's like a
say.
pilot. Can a pilot wear the Sith Lord
Can
costume?
I dress like a clown in court here?
Yes. It's like that.
Okay.
And that's where it
Simple as
becomes
that.
blurry.
Yeah. Open spaces, India does not have a law, unlike, say, France, which tried this for a long time and passed it for a period of time. Eventually struck down, I think, by the ECHR and the ICCPR. But they had this, that their debates are different. These debates have, over the last 3 weeks, while we were discussing, we wanted to do this podcast, have arisen on the on the floor of the Senate in Australia, in, I think, the UK as well. And it has been an extremely difficult and heated debate there. But at least the right over there comes with the correct argument, the honest argument that these are representative of extremism, and this extremism is eating into our society, and that's what we are targeting and challenging. Right? We don't do that in the context of a college, and I get that, because it's a college, it's a collegiate space, right? And so you are really looking at the rule making power in a different sense. Because if you had the broader argument, the one I'm talking about, then perhaps you would have to enforce this across the board, and you'd have to enforce it everywhere. So, for example, Kendriya Vidyalayas fall under the Ministry of Education. They don't have a ban on hijab,
Hmm.
right? And if I'm not mistaken, they don't even have a ban on the burqa. But perhaps their view is that you have to get, 8, 10, 15 year olds into school,
Hmm.
and you're willing to pay a price for that, right? I
Yeah,
may
but
hold a
where do we
different.
draw the line? Like, we've
There you
obviously
go,
left the
right?
line
So I
open,
hold the view that you
for
may
the
bring
Sikh
them into
pagdi,
school.
right?
No,
We
no,
have,
but no, no. Well, that is where our good friend the ERP comes back. You remember the ERP, the essential religious practice? So I'm going to tackle that. That dichotomy I'll tackle. Don't worry about that.
yeah.
So
Hmm.
I'm really just on the point that where do you deal with this idea? Can there be an honest debate on the fact of choice, right? Although the choice question is framed in multiple different languages when it comes in the legal framework, right? Within the constitutional framework. So conscience is one element of it, privacy is one element of it, fraternity is one element of it. So look at it, these three concepts under the constitution is how you frame the larger, more commonplace argument of hijab is choice for the purpose of the constitution, right? So this is why I'm going to go through a few of these legislators, like a couple of these. I'm taking two examples. I'm taking one Bombay example from 2003, and 20 years later, I'm taking the example in Karnataka, right? And just look at the language of how this is dealt with by the courts. And to me, a part of this is a cop out, particularly because we are now in an era where in the Indian Young Lawyers Association judgment, which is the Sabarimala judgment, a 4-1 majority holds that constitutional morality will prevail over any religious morality. Right? Kushal, at some point, I would, in this podcast, ask you to include a small clip from that old podcast I referred to from 3 years ago, which had me, Amana, and Khalid. Okay. And when I open that particular podcast, I make a very specific point, my portion of it, right? When I don't open at the start, I, in fact, come somewhere in the middle for the very first time. I make a very important structural point about the Constitution, right? Which is this. When you look at the fundamental freedoms in Article 19, the way it is written, and perhaps you are going to automatically and reflexively ask me the same question you asked me that day, right? Let's see whether that happens. But Article 19 lays down fundamental freedoms. right? And it lays down the fundamental freedoms seriatim without speaking of any restriction while listing them. And then in a separate clause, it brings in the concept of restriction. Of course, the concept of restriction was narrower at the time of the immediate immediate coming into force of the Constitution of India. And of course, the First Amendment expanded and all that. We know, all of us know all of that, right? That's fine, whatever it is. But I'm on the structure. So the mentality of a judge, and this is what the courts always say, that when you're dealing with Article 19, you are first and foremost dealing with the freedom. And the freedom must have its full say. And once the freedom has had its full say, if you have a balancing requirement, if the law then has to show the highest standard of strict scrutiny standard is what we call it, the highest standard of scrutiny if it wishes to limit the application of the freedom. Now, you and I are massive proponents of absolutism on free speech. And we have seen more than enough examples over the last 2 years, 3 years, where you could turn around and say, boss, you keep saying strict scrutiny, but what strict scrutiny have we seen in the case, for example, of Ranveer Allabadia or Samay Raina or umpteen number of people who had charges against them under 153A where the court refuses to quash, etc. Right? So what strict scrutiny have we actually observed there? It's a different matter. I understand the different courts operate differently and they're really not moving in judgment at that time. They're only passing interim management orders of the criminal process. So they're not going into the questions that we're talking about. And they're only reflecting sometimes their attitudes, which are perhaps a little narrower on that concept than ours may be, right? But that's the structure. 19 will first say you have to have a set of freedoms. And then if you want to limit those freedoms, you have to have strict scrutiny. And you have to very narrowly tailor what your restriction will be, theoretically, right? In reality, whatever it may be. 25 has the opposite structure. That is your freedom of conscience, religion, etc. Right? So let me just, if you want, for the benefit of the audience, you could pull up 25.
25 what? Just Article
Article
25 or
25. Article 25.
any specific bit of Article 25?
No, the entirety.
Okay, wait. Opening up Indian Kanun.
See, one of the best gifts that Justice Chandrachud gave us all is that we all argue from tablets nowadays. My life has become easier. I'm not shuffling paper anymore. There you go. Right. So 25, freedom of conscience and free profession, practice and propagation of religion. See, conscience is placed first. Conscience may be a set of ideals that you hold dear that may emanate from religion or it may emanate from outside of religion, and there may be an overlap. Right. And then free profession, practice and propagation of religion. That word propagation, that's perhaps a part, that's something we covered during the conversion laws podcast. This propagation word is a big problem in 25, right? In any event, I'm reading 25.1 first. Subject, and 25.1 and 2, the distinction between them is, or we'll go through it. Wait. Subject to public order, morality, and health, and to other provisions of this part. So the limitation is what the article opens with. And I want you to make this distinction in the context of 19 that I was talking about earlier. In 19, it does not open with the limitation, it opens with the right. Now, if I apply, because this also falls in the fundamental rights chapter of the Constitution of India, and therefore strict scrutiny will apply, but the structure of the article itself places the restriction above the right. Okay, so let's just do the first principles work first. Subject to public order, morality, and health, and to other provisions of this part 3, all persons are equally entitled to freedom of conscience and the right to freely profess, practice, and propagate religion. Right? Now, firstly, to be noted that this is an article that applies to an individual, all persons. Right? It is not going to a denomination. It is not talking about a sect. You may be part of a sect, you may not be part of a sect, but it applies to your individual practice of your religion. However, it is first and foremost made subject. So if I take those opening words, subject to public order, morality, and health, and the other provisions of this part, and I frame a law that says all religions are banned. And I am able to justify this for whatever reason. Kushal, just stay with me for a moment. On the historicity of how religions have impacted societies and how the elimination of them would eliminate a lot more pain in society. It would also inculcate scientific temper. It would inculcate more discipline and more adherence to fraternity within peoples in general. And it would eradicate distinctions and differences within society that people are otherwise attuned to observe. Right? That's my justification for it. Of course, I'm being reductive when I make that justification. I would have to have a much more elaborate justification, and I would have to show a lot more data. Right? But be with me for a moment. All that 25 does then, okay, it says, yes, you can pass any law, but you cannot eliminate the essential religious practice of any religion. That's where our friend ERP comes from. Right? Because otherwise,
I remember. ये हम लोग ने
right?
last time भी
Right?
यही था कि
How
hijab
do you
essential religious
otherwise, how
practice
do
नहीं
you
है.
reconcile part 1 with part 2? The first clause is subject to the following things. If I pass a law subject to the following things that eliminates a religion, then how do you still have the right as an individual person to practice, profess, and propagate? So to balance that out, the court says, okay, we are only giving you the preserve of an ERP. That's your protected domain in a religion. Now come back again to what I was saying in the context of 19. You can't do that in 19. You can't say the restriction will dominate freedom of speech to such an extent that I will encumber it into a narrow space where virtually it is reduced to, you're able to speak, you're able to type. That's all. That's not good enough. Therefore, the statuses of both of these are different in the Constitution. That's my first point. Right? And that's where this nothing here says essential religious practice. But that's a device the court started to develop because it was like, well, we're seeing law after law, good law after good law coming in. And it's being challenged in a religious practice. And if we keep supporting the second half of this article, then the first half becomes odious. Whereas the way it is drafted, the first half is the thrust. It is, in fact, is stated aim to move beyond religiosity. Now, when you examine the constitutional framework in that light, now look at a person walking into a college with a hijab and the rights and the powers of that college to pass a rule against it. So I read 25. Sorry, I read 25. Just let me complete this. This is a bit about the structurality of the constitution, and it's important that I complete this because this will otherwise confuse people later. Uske baad we can get into a back and forth debate, and I'll go into the judgments I want to cover as well. 25.2 is not with nothing in this article shall affect the operation of any existing law or prevent the state from making any law. Again, the power is given to the state in negative terms. Regulating or restricting any economic, financial, political, or other social activity which may be associated with religious practice. Social activity, for example, or other secular activity, because religion can't be only ritual, right? For it to perpetuate, it has to have certain secular activities involved with it by definition. And you can regulate that. The manner in which you fraternize may be regulated, for example. So today, theoretically, therefore, under 25.2.1, you have Muharram processions. Just taking that example. Or you have, on the one hand, and you have, say, Ram Navami processions on the other hand. All right? The state can turn around and say, that's the actual congregation is a secular activity. I am regulating this. This many people, these are the hours, these are the areas you will walk into, you will not walk into any other areas. These are your restricted domains. That's all. Perfectly valid law under 25.2. But please note, Now we are talking about the law, the rights of a religious group. Unlike one, we were talking about the rights of a religious individual. So when we talk about the hijab judgment, hijab cases, there's a duality. Petitioners will first argue 25-1, and then they will go to 25-2, that you are hurting us, hurting our religiosity with under 25-2. Providing for social, nothing in this law, nothing in this article should prevent the operation of any existing law or prevent the state from making any law, providing a social welfare and reform, or the throwing open of Hindu religious institutions of a public character to all classes. That's specific to Hindus in 25-2B. But 25-2A applies to all, right? So I hope I'm crystal clear on what I'm trying to actually assert here, which is, now look at your explanation one. This is in the Constitution because you asked me this question. You can read it out loud.
Which specific bit you want me to? The whole
Explanation
thing?
one. Just below 25-2B.
The wearing and
explanation one.
carrying of kirpan shall be deemed to be included in the profession of Sikh religion. Essential religious
Right?
practice. So they
That's
can do
a
it.
stated constitutional exception carved in. There is no determination to be made by a court.
मौजा ही मौजा.
Sorry?
ओना दी मौजा ही मौजा, मैं ये बोल रहा हूँ.
For some reason, your voice is cracking, Kushal. Be honest with you, my internet is perfectly fine. I don't know if you have an issue at your end. Anyway, and the second explanation is with reference to Hindus again, and that Hindus include Sikhs, Jains, Buddhists, and the reference to Hindu religious institutions includes their religious institutions. So that's all I wanted to point out. This is what 25-1 and 25-2 look like. And this will become important because of the way Justice Dhulia deals with Article 25 in the Karnataka hijab judgment. So just keep this in mind on the structural aspect. I had made this point in the last debate as well, in the last podcast we did on this issue as well, but perhaps not to the sort of granularity to which I have done today.
Voice is okay, Nikhil, by the way.
No problem.
Listeners
No
ने बोल
problem.
दिया.
No problem. Ignore it then. Ignore it. Now, लोगों को ना कंफ्यूजन बहुत ज्यादा हो जाती है इसकी वजह से कि बहस कैसे करनी है इसकी. So now you look at hijab. You can take this away now. So your college introduces a ban on hijab, headscarves, etc. Right? When you challenge partly on Article 19, freedom of expression, and partly on 25. But my position to you is this. If your challenge under 19 is unsuccessful, your challenge under 25 has no chance because of what I just explained. Until and unless you prove that hijab is an ERP, an essential religious practice. Okay? That's just first principles. Okay? I hope that's clear to people that if you fail at 19-1A because your protection there is greater, then you're bound to fail at 25. Unless you prove it's an ERP. So the first judgment I want to look at, I'm going to look at just two judgments today because I don't want to go on.
No, I was just thinking, like, how do they define what is an essential religious practice?
I am going to give you a concrete definition of that today, but it is a limitation definition. It is not a positive all elements definition. It's a definition of limitation in as much as what is it not. Okay, but it's clear enough. It creates enough of a concrete setup. Sorry, Kushal, you give me a minute.
Yeah, sure. तू कर ले. तो अपने आप को म्यूट कर ले, चाहिए तो मैं तेरे को म्यूट कर देता हूँ, तेरे को अनम्यूट कर दूंगा.
Yeah, just mute me.
Yeah, so you can, on the topic of institutions, what about the LG of JNK's decision on SMVDU admissions on the basis of religion? Does University Grant Commission get a say in privately funded institutions? Yes, because वो privately funded की line अथर्व is very vague and we cannot define that. Okay, बोल निखिल.
Right. So, Bombay High Court has done this twice. And I'm going to take the later judgment because it also cites the former judgment. So, the later judgment is Zainab Abdul Qayyum Chaudhary and others versus Chembur Trombe Education Society. And NG Acharya and DK Marathe College of Arts, Science and Commerce and others. You would know these, being a Mumbaikar. Two judges. If it matters to people, let me be clear, two Hindu judges. I don't know if it matters or not, but that's how it is. And in this case, what had happened at 9 students pursuing their second and third year education, undergraduate courses at the college run by the first respondent, that's Trombe Education Society, have raised a challenge to the instructions issued to the students, requiring them to follow the prescribed dress code in addition to notice come WhatsApp message dated whatever issuing instructions in the matter of following dress code is also under challenge. The petitioners allege that the prescription of the dress code as a result of which they are restrained from donning a hijab or niqab is arbitrary and discriminatory. It affects their fundamental rights guaranteed under 19(1)(a) and 25.
It's funny when all these things basically come to fore when it's two minorities fighting. I always wonder about that.
We're going to come to that because the game changes there.
Yeah, because then it is both are minority institutions.
That's right. And the one that owns the institution has the full power. Can't do a thing. Anyway, one of the arguments they raised here was, look, if we had prior notice, we would never have joined these colleges. We had no prior notice. When we joined, this ban didn't exist. Now you're introducing the ban. Right? So, now coming to the core of their arguments, referring to Articles 19(1) of the Constitution of India, it was submitted that the petitioners could not be prevented from dressing appropriately by donning a hijab or niqab since they had a right to expression. The restrictions imposed affected the petitioners' right to dignity and bodily integrity. Right? So they pitched the hijab to that level, that this is my individual expression of it. And in a true sense and in just a practical sense, I'm actually adhering to the uniform requirement. I'm dressing decently. And if anything, a hijab or a niqab is even more decent. That's literally the argument here. I'm not kidding with you. You can pull this judgment out. The citation of it is 2024 SEC Online Bombay 1925, 1925. And in para 3, you'll find the argument that
2024 SEC
Online 1925. And in para 3, the argument is, on the contrary, students were permitted to wear a formal and decent dress, while girl students were to wear any Indian Western non-revealing dress. By this manner, hijab and niqab were said to be labeled as indecent for being worn by girl students.
ये कौन सी वेबसाइट में आएगा ये सर्कुलर?
You won't see it. You won't see it. This is for practitioners. But SEC Online is probably the most widely used search engine for judgments. Kushal, your screen's frozen, man. This is your end, not my end today.
Hey, bhai, मेरा इंटरनेट 1 gig
I'm telling you.
अरे मान जाते.
मेरा इंटरनेट मोटा भाई का है.
हाँ तो मोटा भाई बहुत गंदे वाला इंटरनेट देते हैं. Anyways, it's fine. I can watch you. I can hear you. तो बोली जा.
So part of it was that if the entire sort of requirement, sorry, I had to put the charger in. If the entire issue is that you have to have a decent dress code, well, these only add to decency. What's the issue? Why aren't you allowing us to wear them? There really should be no limitation on this. And so the question they are asking is, what is your problem with a headscarf? So that's effectively what a hijab comes down to. And that's why I want to come back to that point I was initially making, that the hypocrisy of not being honest about why you oppose all of this, right? Because in response, you'll have to say, we don't want people exposing their religiosity per se, or wearing exceptional or extensive religious symbols. Everybody's gonna wear some religious symbol or the other at some point in a country like India, yeah. That's when this becomes a hypocritical argument. But anyway, let's proceed further. They also raised that hijab or niqab is an ERP. Whether they are successful in proving that or not, we'll have to see. But they do raise it. Like I said, in the decency argument, if your rule is about presenting yourself with decency, then in fact the dressing items that were prohibited were decent, and it could not be said that the restrictions imposed were in any manner reasonable. So they're not opposed to decency. And this is, in a flippant way, you will get highly religious people on either side saying, boss, isn't it better than someone wearing a mini skirt to college? This is typically what they come up with, because the mentality is exactly the same, right? The mentality of a hijab is the same person who has a mentality of saying, why a mini skirt? Because the idea is of policing. The idea is of restricting the female choice here. So, and I say that very consciously, because I know, in opposition to what I say, people will say, but hijab is choice. No, hijab is not choice. Not in my eyes. That's a larger philosophical debate we'll have later on during the course of this podcast.
Yeah, because
The
like,
state,
if a student says, I want to wear a bikini and come to school, nobody will say, nahi, nahi, allow karna chahiye, choice hai, ye wo.
no, see, you would be afoul of the rules in the same way.
That's my whole point, which is why the hijab ban
Yeah.
is fine in institutions.
So, now this is a bit about the respondent. That's the state's argument, or the society's argument, that I found interesting. And to me, this is sort of the heart of what they say, and this is where I'm saying the hypocrisy steps in. The object behind prescribing the dress code was that the religion of the students should not be revealed, and that discipline in that matter was sought to be ensured. The restrictions imposed were only in that regard. The students taking education in the college sought to focus and concentrate on their studies, and it was with that object in mind that the dress code had been prescribed. Moreover, the college had provided a changing room for the girl students to ensure that they were comfortable inside the campus. It was then submitted that the college had the necessary authority in law to prescribe a dress code. It could not be interfered with if the same did not result in violating any constitutional rights of any student. This is important. One side says justify yourself, the other side says no, no, you justify yourself. And this is why I opened with that explanation of 25-1 and of 19 separately. If this is a 19 argument, yes, you have to justify yourself. If it's a 25 argument, no, the other side has to justify themselves. Right? So,
I don't know. I can't believe that in a country like India, these things are even a problem. Like, I find it hilarious. भाई तुम अपने स्कूल खोल लो यार, तुमको इतना अगर सिथ लॉर्ड बन के जाना है तो. और क्या है यार, डार्थ वेडर में और क्या. मेरे को तो कोई शर्म नहीं आती, मैं आज से थोड़ा ना बोल रहा हूँ ये, तो पहले से ही बोल रहा हूँ. आई तो हैव डीप प्रॉब्लम्स विद दिस.
no, I'm coming to that. So now the court starts discussing everything that they've heard, and they say WhatsApp message. The WhatsApp message was, "You shall follow the dress code of the College of Formal and Decent Dress, which shall not reveal anyone's religion, such as no burqa, no niqab, no hijab, no cap, no badge, no stole, etc. Only full or half shirt, and normal trousers for boys, and any Indian Western non-revealing dress for girls on the college campus. Changing room available for girls. Okay, so this is the intent with which they are approaching this. And there was a 2003 judgment of the Bombay High Court, because in Bombay periodically this shit has to come up. So in Bombay High Court in 2003, in Miss Fatima Hussain versus Bharat Education Society, a direction issued by the principal of a high school to a girl student that she could not attend class wearing headscarf was under challenge. On behalf of the student, it was argued that the direction issued by the principal was violative of fundamental rights of freedom of conscience and professing, propagating, and practicing Islam religion. Considering such challenge, it was held that by merely asking the student to maintain the dress code prescribed by the school, it could be said that the student's fundamental right of freedom of conscience and free profession, practice, and propagation of religion was violated. There was no breach of the provisions of Article 25 of the Constitution of India, but please note, in that judgment, they were not wise enough to use 19(1)(a). Tactically, 19(1)(a) is a sharper argument. What you will find in the Karnataka judgment is 19(1)(a) is what Justice Dhulia will base his argument on, his judgment on, and uphold their rights. And therefore, you get a split verdict of two judges, and now that's pending before a larger bench of the Supreme Court. By asking a petitioner who is a student of class 6, in this case, in Fatima's case, that's a class 6 student, to maintain desk code prescribed by the school, how can it be said that the petitioner's fundamental right of freedom of Article 25 was violated? Like I'm again pointing out, they didn't have an analysis on 19(1)(a). And that's something that we will come up with as we go along, right? Now, there's the state of Kerala judgment as well. And it so happens that is also one Fatima, that is Fatima Tanseem, that there may be a fundamental right for a student to choose a dress of his or her own choice. There is also a fundamental right of establishing, managing, and administering an educational institution. Between the competing rights, an individual could not seek imposition of his or her fundamental right as against the larger right of the educational institution. On this premise, the challenge was turned down. So, Kerala High Court in 2019 takes a different kind of analysis. It says, okay, you have an individual assertion, that's a group assertion. We're going to accept the group assertion because somebody has to run a college or an educational institution, and so let them run it in the way that they deem best, and we're going to be limited in our interference unless we find something particularly objectionable.
It's
While
literally,
considering the
at
present,
times I feel it is at the discretion of the judge.
no. I am reading this judgment to you, and I'm speaking on the other judgment. That was the point I was going to make, or let me make it in the correct sequence, okay? Because I'll come back to this thing that I explained at the start, and I will explain in that context again. While considering the present challenge, it must be noted that what has been done by the college in the form of instructions for students is to prescribe a dress code of the college. The regulation of such a dress code has to be treated as an exercise towards maintaining discipline of the institution. This right flows from the recognized fundamental right to establish and administer an educational institution under 19(1)(g) and Article 26 of the Constitution of India. In TMA Pi Foundation, it has been held by the Supreme Court that the aforesaid fundamental right to establish and administer an educational institution is subject to the provisions of 19(6) and 26(a) of the Constitution of India. We do not find as to how the prescription of the dress code by the college offends the provision of 19(1)(a) and 25. Now, again, if you raise 19(1)(a), they come back with 19(1)(g). I also have a right to run my educational institution. And if I'm running an educational institution, I have a right to administer it as a fundamental part of that educational institution. And if I am prescribing rules, you are compelled to comply with those rules because they are a narrow restriction of your otherwise available right under 19(1)(a).
I forget that if it's a institution and that to a minority run institution, तो फिर तो double trouble हो गया.
फिर तो कोई सवाल ही नहीं है यार. किसी का कोई सवाल नहीं है.
And minority is not just religious minority, even linguistic minority is considered minority as far as the right to education is concerned.
So in this judgment again, they go into that same idea that insistence of following the dress code is within the college premises only, right? So it's a limited restriction. It's only within the college premises. You can wear a hijab up to the college gate. You can go into the changing room. You can take off the hijab, attend your classes, and then when you're leaving, you can wear your hijab again.
So I'll give you a prime example of this. Most people may not know this, but a lot of girls that are working in these coffee shops, cafes, serving you, you may not understand that they are Muslims. As someone who visits a cafe regularly in Mumbai, I have seen this so many times where girls, invariably Muslim, they enter for their shift in a hijab, fully covered like a Sith Lord, go to the washroom, come out with their uniform of the business, do their shift, then again go back into Sith Lord mode, and then they go back home. This happens all the time. Now, what will happen tomorrow? What somebody will say, I need to dress up like a Sith Lord, and you cannot stop me from wearing this dress code because I want to serve. And that business runs out of business, but the business has a uniform for everyone. What is the court going to do in Kerala then? Again, tell कि नहीं, group
Brother,
rights
let me
over
be clear about
education.
this. Let me be clear about this. The 19.1G right will be even stronger over there. It'll be stronger than the 19.1A right there, even stronger. Because there you are putting your money in and you're paying this person. It's even stronger than a college-based circumstance. So the court will say, all right, go work somewhere else. End of story. You're fired, you're fired.
You know, like I'll give you another real life scenario in a
So let's just do
stockbroking
the
firm.
principle, the first principle thing. 19.1A, I say a hijab is my expression. Court says 19.1G, sorry, right of the operator of the college or as you said, of the commercial establishment to set their own rules. They have their freedom there. You are limited. The only answer that the first person can come back with, the hijab wearer can come back with, is no, sorry, under 25 my hijab is an ERP. And if it was an ERP, then you prevail. Perhaps prevail. But most likely you prevail from that point.
Got it.
That's because you asked me what is the logic, the constitutional structure and the logic. That's the logic. That's how it sort of works. But see how we tend to muddy this a little. In this judgment in para 13, all the above guidelines and instructions attempt to promote a non-discriminatory atmosphere in higher educational institutions. The object is to discourage discrimination on any count whatsoever. They're not willing to go around and to actually take it to the point and say, we're not attacking headscarves in general. We're attacking in specific the hijab and the niqab and the burqa. On the first principle that these represent extremism, they represent what do you call a, a regressive way of thinking. And much as you would not want a ghungat on campus, not possible, right? So I know of a lot of right wing accounts back in 23 when this broke, and I sort of stopped following some people. They stopped following me because I was very adamant about you have to stick to this principle. There should be no other principle used. The principle has to be of regression, right? If you go back to our podcast from 3 years ago, and this is something it's the first time I met Amna, online or offline, okay? And Amna was so good, so particular, so specific. It's, I think, the third or fourth section of your podcast that day where she starts by saying the number one problem with a hijab or with niqab or with a burqa is that it is a symbol of patriarchy. It's a symbol of control. It is not a symbol of choice, right?
Yeah,
But we don't tend to.
she was coming at it from first principles, but that's what I
That's
told you.
right. That's right.
A lot
What
of
am I trying to come back to you?
surrounding commentary on this subject when it comes to the internet is literally competitive bigotry.
No, but that's to any topic. Yeah, you bloody bring out the ashes. Eventually, there'll be comparative bigotry in the ashes also. Yeah. I mean, come on, this is the internet. This is human beings that most of them are low IQ and they tend to give in to
And
their
in
most
India,
basic. Yeah.
there are an extra demand.
Like, why? But there is a very simple part. I'll tell you something very straightforward, right? I go practice in the Delhi courts, okay? courts like Tisazari, Patiala House, where I do my criminal matters, right? Saket, etc. Because these are like minor townships. They're that densely populated, that many people come in a day. You meet people from every religion, every background, every faith background, every caste background, and you don't even realize it. It's seamless, right? Real life on the streets in India is mostly seamless. If you take Twitter to be the standard of what's happening in every country in the world, then every country is burning. So, for example, California has become third world as per Twitter, and India is catching up, right? Patently untrue. I can promise you that. I have relatives who live there. Or that in India, Muslims are dying on the streets every single day. Patently untrue. Doesn't happen. Or that in the UK, various kinds of other troubles are happening. So, social media and the online projection of what reality is just, it really bores me beyond a point. And I don't look at the fringe side of the debate. I don't look at it, but you'll perhaps give me a good reason why I should look at it. But as a lawyer, I don't look at it because I know the fringe argument never makes it into an enforceable setup within a government. The day it does, I will look at it. Honestly, or the day I start feeling like it will make it there, I'll look at it. I just want to point out to everybody who used to say that the Hindu right will bring fringe laws, fringe ideas into the public domain. These are not fringe justifications. This is, in fact, running away from the core justification. These are high level justifications that have always existed. And there is a plethora of case law that gets cited in both judgments about the kab se chal. No variation. Every time it comes up, it's as if look at what the BJP is doing. No, it's not just the BJP. Everybody has had this idea. Everybody has had it. And like I said, in the context of the PFI judgment, the Solicitor General specifically raises the point that I call it the PFI judgment, but it was really the Karnataka Hijab judgment, that PFI suddenly is stoking these fires. Right? They want to test the limits of what you will call religious freedom. Are you willing to yield on this on religious freedom? I'm kind of upset that Justice Dhulia took the bait without looking at the reality of what's going on. Right? But with that as may, so finally, this is really the heart of what the court says. All the above guidelines and instructions attempt to promote a non-discriminatory atmosphere in higher educational institutions. The object is to discourage discrimination on any count whatsoever. So, in fact, what they want to step away from is to say that perhaps having religious symbols everywhere, or they want to step into this, is to say having religious symbols everywhere will create little islands, little silos of students who will perhaps be distrusting of each other and will not be fraternizing as much. If you have people who are hyper religious, I don't know about you. I went to a college, Kushal, where I didn't see particularly too many people of a hyper religious ilk. Those that I saw, I've always tried to maintain good relations. If I've had bad relations with someone, it's never been on a religiosity issue. But I would also not be tempted to be close to them. It's just not the nature of me. And I'm trying to say that what happens then is that this fraternizing argument is actually a good sounding theoretical argument. It's not a factual argument. Fraternizing doesn't, in fact, happen. When there's high levels of religiosity and high levels of symbolism on campus, there's actually a great distinction. Or you need woke levels mind capture. That you overcome all of your otherwise well-reasoned ideas of, I want to avoid this, and be, in a sense, extorted or blackmailed, emotionally blackmailed into accepting whatever is being thrown at you. And that then we get into the problem of relative morality and subjective morality, etc. Right? So I'll now come to something very interesting that another judge, that the Karnataka judgment did, because I'll now start quoting from bits of that. So the Karnataka judgment took upon itself the task of trying to define secularism, right? Which is fair enough because secularism has to be defined. and has been defined by or attempted by various judgments. And the authoritative judgment is judgment SR Bomai versus Union of India. This is one of those judgments that it's a long judgment, it's a difficult judgment at times. It's on federalism. It changed everything in relation to the exile 356 uh, and dismissal of state governments. You know, people should read at least summaries, at least AI summaries of judgments of this sort. SR Bomai is vital. Like, people should know it. So SR Bomai has this very interesting set of definitions. The provisions by implication prohibit the establishment of a theocratic state and prevent the state either identifying itself with or favoring any particular religion, religious sect, or denomination. The state is enjoined to accord equal treatment to all religions, religious sects, and denominations. Right? That paragraph cannot be called into question when dealing with a hijab, because with a niqab or hijab ban, because it's not as if you're preferring any other religion either. You are not saying you will not wear a hijab, but you will wear a tilak. Right? There is no mandate there. The next is one thing which prominently emerges from the above discussion on secularism under our constitution is that whatever the attitude of the state towards religions, religious sects, and denominations, religion cannot be mixed with any secular activity of the state. In fact, the encroachment of religion into secular activity is strictly prohibited. You find this in the approach of the judges. The judges want to constantly say it is non-discriminatory, it is absent of religion, it is a power within 191G, it is a power given to a university because they are best placed to determine what handles the discipline and the unity of a college better. And so you leave that discretion to them entirely. Both the expressions socialist and secular by themselves are not capable of precise definition. We are, however, not concerned with their general meaning or content. Our object is to ascertain the meaning of the expression secular in the context of our constitution. As the discussion hereafter would demonstrate, the 42nd Amendment merely made explicit what was implicit in it. I keep saying this, right? People keep coming back saying, what would happen if secularism was not inserted in the preamble, as they say, surreptitiously in 77? It doesn't make a difference. You still had a secular constitution. 25, 26, 29, 30, 27, 28, they're all secular provisions. They essentially stop the state from making laws in favor of one religion over another, not allowing the enforcement of one religion over another. While the citizens of the country are free to profess, practice, and propagate such religion, faith, or belief as they choose, so far as the state is concerned, from the point of view of the state, the religion, faith, or belief of a person is immaterial. To it, all are equal and all are entitled to be treated equally. How is the equal treatment possible if the state were to prefer or promote a particular religion, race, or caste, which necessarily means less favorable treatment of all other religions, races, and castes? How are the constitutional promises of social justice, liberty of belief, faith of worship, and equality of status and of opportunity to be attained unless the state eschews the religion, faith, or belief of a person from its consideration? Now come back to 25.1. All of this is very nice sounding. You have to keep it equal. You can't have preference based on various of these creeds. That is why 25 says you are subject to public order, morality, etc., and to other provisions of Part 3, thereby saving the discrimination that is inherent, the preference the state gives inherently in reservations. Right? And so those are not deemed to be religious benefits given to one particular religion. So they are saved inherently by Article 25. In other words, secularism is neither anti-God nor pro-God. It treats alike the devout, the agnostic, and the atheist. According to him, secularism is not antithesis of religious devoutness. He would like to dispel the impression that if a person is devout Hindu or devout Muslim, he ceases to be secular. This is a quote of Justice H.R. Khanna, one of the most famous judges. All sounds good, but I just want to come back to this. Treats the agnostic and the atheist alike with the religious, with the devout. Can we really say that when we have 295A and 153A?
नहीं यार मतलब
Obviously,
क्या
my
है
right
ये
है.
मतलब I'm sorry, this is like, I mean, अभी फिर contempt of court हो जाएगा, मैं कुछ नहीं बोलूंगा.
नहीं कोई contempt नहीं होगा. You should speak up. You should speak up about
Like,
it.
what is
Things
this
like,
yaar? Like, do these judges don't understand basic philosophy?
brother, I that's exactly what I opened with today. That's exactly what I opened with today.
It is so frustrating यार, ये मतलब क्या है कि नमक शक्कर है, शक्कर नमक है
बस 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 बस, सब कुछ सब है और सब कुछ कुछ भी नहीं है।
यार, ये
जब
मतलब
जरूरत
क्या
पड़े
है?
उसको
होकस
सब कुछ
पोकस,
बना
दिस
दो,
इज
जब
जस्ट,
जरूरत पड़े वो कुछ भी नहीं है।
this is hocus pocus, man. This is literally hocus pocus.
So every time I have to read these judgments, I swear to you, I have a sense of dread. Okay, these long concept, because I'm like, भाई ये तो चपाती पराठा नान सब कुछ एक साथ बनने वाला है
सब कुछ है,
और
जो चाचा है वो
पता ही नहीं
भतीजा
लगता कि
है,
क्या
जो
हुआ इन
भतीजा है
दोनों में।
चाचा है, वो चाचा भतीजा एक ही है, बस ऐसा
वो
ही
मतलब
है।
there you go यार।
So ridiculous, man. Like, I can't believe these things come in judgments. Like, क्या है?
Now, I just want to read जो कर्नाटका में हुआ था ना, the actual government order that was passed. Okay, I'm not going to read it in full detail, but they essentially they try and do out as justificatory as they can possibly be, which is typically not what government orders are. Government orders just say do X, Y, Z, right? They don't sit into justification, but these guys sit into justification. They even try and bring out a constitutional history. This judgment allowed us to do it. That judgment, so they tried the Bombay judgments I was discussing, etc. And they allowed us to do it, and this allowed us to do it, and that allowed us, so we are doing it. But the core paragraph, and this is their justificatory paragraph, right? Various initiatives have been undertaken to ensure that students in schools and colleges have a standardized learning experience. However, it has been brought to the education department's notice that students in a few institutions have been carrying out their religious observances, which has become an obstacle to unity and uniformity in the schools and colleges. The question relating to a uniform dress code over individual dressing choices has come up before various courts, before the Honorable Supreme Court and High Court, which have ruled as follows, and then they cite these cases. And they, in fact, get one of the citations completely wrong. They completely miscite it. It has nothing to do with hijab and nikah. उस पे आर्ग्यूमेंट बनती है this shows that there is no application of mine. Anyway, immaterial right now. This is what they use to justify that colleges can pass their own laws, right, on own rules, and eventually a set of issues are framed. And Justice Dhulia does a very good job of producing all of these 11 issues, because he divides his judgment into 11 issues on page 23. May agree, disagree with Justice Dhulia, that's fine, but at least there's structure to what he's doing. And so one of the arguments that was raised was, boss, you can't even decide this today. You have to stay this tactical argument, stay the rule, don't decide this, because the question being raised is, what is the nature of an ERP? Can it be delineated at all? And that has gone in the reference from 5 judges in relation to the Sabrimala judge. Okay. My and luckily the court doesn't fall into that and says, forget about all that rubbish. Your position is slightly different from Sabrimala, which is good, because Sabrimala has a completely different outlook to it. Sabrimala is different because it is within a religious space. It is not in a secular space. So the question there is, can the ERP have a greater protection in a religious space to oust the private rights, the otherwise guaranteed fundamental rights of a class of people, of a class of citizens, right? So, in other words, the question in Sabrimala is, are we allowed to comply and follow with our religious myth within our religious space, knowing full well that the compliance with that myth obviates the fundamental rights of a category of women, which is in specific menstruating women? Right? Very, very different from what this is. And so the court doesn't fall into that mistake. Then certain other administrative law arguments are raised. If you have to have a hijab ban, it can't be done by a college development committee. Court says, nah, you can do it. These are administrative law arguments, not material to us today. They raise certain very there is a very interesting argument. This is just a historical argument. First up, let me be clear that constitutional amendment debates are not going to determine the meaning of the constitution for us today. Okay? Because eventually a constitutional assembly debate is also the opinion of one person. And debate eventually succeeds or fails, whatever, it is eventually translated into a provision in the constitution. So it is the reading on the face of the constitutional provision that matters far more than what the content of the debate is. Of course, you could look at the debate to have an idea of the framework, of the environment, of the idea set within which that particular provision was being discussed. So, very interestingly, one of the things that was raised was that I want to find this because this is really something that I think people will find interesting. Huh. There was an amendment proposed by one Mr. Tajamul Hussain on 3rd December 1948, proposing an amendment to the following effect. No person shall have any visible sign or mark or name, and no person shall wear any dress whereby his religion may be recognized. Okay? This was a proposed amendment to be included in the constitution. A bizarre amendment, if you ask me, because how do you do this? How do you? This is a massive encroachment into the individual sphere to say that I'm going to pare away religion to such a degree. But it's very interesting to me that this was raised by a Muslim, because I think today you wouldn't find a single Muslim within any legislative domain who would want to raise this. Although you will find so many of them that I know would happily raise the same point. Otherwise, in debates that I have with them, the argument raised is that since the amendment was not accepted, therefore citizens have a right to have visible sign or mark or name or dress so that the religion may be recognized. Ye dekho. You understand what happened here, Kushal?
अरे
Essentially, they
मतलब
say
क्या
that
है ये?
वही तो मैं कह रहा हूँ. Some of it is so the first principles just do your head in, right? Like, so he's saying that
अरे
because
this
that
is
amendment
bizarre.
failed.
This is bizarre. It's irritating me now.
Yeah. Because the amendment failed, which would have restricted every mark, that means by implication you are allowed every mark all the time.
यार क्या है यार? मतलब ये क्या हो रहा है यार?
I have
Tattoo.
sympathy
They
with
will
people
allow
like me, man.
tattoos. They will allow tattoos.
मतलब क्या बोले आदमी यार? The students at the time of admission to the pre-university course undertook to comply with all the rules and regulations. This is from the other side. It was pointed out that suddenly in the middle of the academic term, the issue of hijab was generated in the social media by the activists of the Popular Front of India. The police papers in this respect were handed over to the High Court on a sealed cover as mentioned on page 126 of the order of the High Court. It is stated the charge sheet has since been filed. Thereafter, some representations were made by the parents of the students and or students requesting hijab to be worn in classroom. This is important. This is the shit that nobody follows up on. And this, you can't follow up on this because you're doing it in a writ petition. If you were doing this in a suit format, then everything would have to be proved by facts, and this evidence would be available to us in a judgment and not in some bloody sealed cover. That PFI activity increased in the area, Udupi area and other areas, after which suddenly this hijab issue is raised. Right? And if you make that into a core fact, then you can correlate back to the argument I was making in the beginning that Amana so well argued last time we did this topic, which is that this is a regressive practice that has to be banned. It can't just go on like this. I don't want to keep going into this judgment because I think we should at some point come back to, then they go into ERP, how it's not an ERP, why it's not an ERP. One of the most amusing things, I'll just give you a couple of amusing things from this. The ERP, the first thing the judge says, to appreciate the argument raised, I firstly need to examine the tenets of Muslim law. Imagine a secular judge in a Supreme Court in a country sitting and saying, I have to now examine tenets of Muslim law.
यार this is the failure of Indian secularism. यहाँ तो हमारे यहाँ पे सर से लेकर पैर तक यार nobody understands what secularism is.
Yeah. No, bhai, wait. Now let me tell you how far that paucity goes, because some of these examples are spectacular. This is the kind of shit that has been brought to courts to say that that this is an ERP. So, as an example, in a judgment reported as Muhammad Hanif Qureshi, this court found that the sacrifice of a cow to not be obligatory and essential to the religion of Islam. One brother had brought a case saying that sacrificing a cow is my obligation under Islam and tried to argue that it's an essential religious practice.
This
The court
reminds
negated
me
the
of,
argument of the.
of Arun Shoury's book that I recommend everyone to read, The World of Fatwas. The kind of shit questions people ask.
Yeah. So the court negated the argument of the appellants when it was held that there was no material on record before us which will enable us to say, in the face of the foregoing facts, that the sacrifice of a cow on that day is an obligatory. Just to be clear, it was on a specific day with a particular Eid. Is an obligatory act for a Muslim to exhibit his religious belief and idea in the premises. It is not possible for us to uphold the claim of the petition. But courts have to deal with shit like this. I wanted to cover this guy. This guy is my favorite guy. Okay, get ready. Later, a 3 judges bench judgment of this court reported in as Javed and others of the state of Haryana negated the argument that no religious scripture or authority has been brought to the notice of the court which provides that marrying less than 4 women or abstaining from procreating a child from each and every wife would be irreligious or offensive to the dictates of the religion. Our brother had a problem because a bunch of Zilla Panchayat rules had been passed in Haryana saying that if you have more than 2 children, you can't contest for elections. So he tried to say that under Islam, it is an ERP that I must have 4 wives and that I must have at least 1 child from each one.
I give up. I'm sorry. Like, Islam provides the most weird scenarios.
No. There are others. I'll give you one just to just to even things up. Anand Margis wanted to do the Tandav on the streets, proper Tandav on the streets, along with sacrifices, etc. Court said, "Bhai,
यार ये
not
लोग
allowed."
क्यों हैं?
This
क्यों
is also
होते
not
हैं ये?
होते हैं भाई, क्या करें, देश ही ऐसा है। वही तो मैं कह रहा
अरे
हूँ,
यार
religiosity.
मतलब पागल लोग हैं क्या? मतलब क्या
If you
इनके
have to
सॉफ्टवेयर कभी
beat back
अपडेट नहीं हुए क्या?
religiosity, if you have to beat back religiosity, you will have to do these things. What is the prescription against caste at which eventually our formulation is perhaps failing? Even Anand, what's his name? Tel Tumde? What's his name, yaar?
हाँ, आनंद तेलतुम्बडे. Yeah.
Yeah, he had a wonderful article the other day on how our framing of how we use caste for benefits is actually reinforcing caste. And we've got to move past all of this. Right? So if you want to beat religiosity, all of this needs to be done. Anyway, makes a wonderful ERP summary. And then he says, so तुम्हारा turban की argument आई थी. Turban was dealt with in Gurleen Kaur, was a state of Punjab in Punjab and Haryana High Court, held to be an ERP of the Sikh faith. So it's not at parity. I'm not going to get further into this judgment because it is quite clear that what the court is doing, Justice Gupta is doing in this Karnataka Hijab Supreme Court judgment, which is a split verdict of Justice Gupta and Justice Dhulia, is Justice Gupta is quite clear of that chronology I had set up at the start. And so he says, in 25, I find no reason. You're a college. You have every right. The reasoning you've given is solid enough. That works for me. That's the end of 25. If you want to now win, you have to be able to show an ERP. 19.1a is the other argument. On 19.1a, he says this is a reasonable restriction. 19.1g applies. That's the end of the matter. I'm done with all of this. Justice Dhulia. By the way, while we're at this, because this is one of my other favorite ones on ERP. Absolute favorite judgment. In Muhammad Ajmal Khan versus the Election Commission of India, the challenge was to the electoral roll with photographs, particularly of Muslim Gosha women in the eligible voters list. The argument was that wearing a parda by Muslim women is one of the principles laid down in the Holy Quran and it has to be strictly followed by Muslim women. Therefore, any interference with such religious practice would amount to interfering with the fundamental rights of Muslim women, which is guaranteed under Article 25. The Madras High Court dismissed such petition, holding that such direction of the Election Commission is not violative of Article 25. It was held the decision of the Election Commission of putting photographs in the electoral roll was taken with a view to improving the fidelity of the electoral rolls and to check the impersonation and eradicate bogus voting. They wanted to come in and say everybody is going to have their electoral roll photographs taken behind the parda. So that you'd have a black photograph for everybody. I mean, what can one even do, boss? Anyway, so Justice Dhulia makes this into...
Nay, you don't get a right to vote. You want to vote, show your face. Otherwise, go to hell.
Yeah. Now, in para 17, Justice Dhulia, in his judgment, does something which I find interesting. He says, in my opinion, the question of essential religious practice, which we have also referred to in this judgment, was not at all relevant in the determination of a dispute before the court. I say this because when protection is sought under 25(1) of the Constitution, as is being done in the present case, it is not required for an individual to establish that what he or she asserts is an ERP. It may simply be religious practice, a matter of faith or conscience. That I don't agree with. That is not the law in India. That I completely don't agree with. I may not like the ERP test, but the test exists. Right? So he completely inverts 25. What I was explaining earlier. And then he says, yes, what is asserted as a right should not go against public order, morality, and health. No, it's not that way around. It is that if the law is in favor of public morality and health, then it doesn't matter what your right is unless you establish an ERP. He inverts the interpretation of 25. And that's a bit of a sleight of hand that I think is a little unfair.
You know how much mental gymnastics you have to do for bogus, rubbish, religious things in a country like India. Seriously, I mean, the simple answer is the idea sucks. Move on. Doesn't matter if it's religious. Oh,
He
man.
then says this is hit by the doctrine of proportionality. I don't know where he gets the idea of proportionality. He gets it under 19(1)(a). Correct? So if you have to have a restriction on my freedom of conscience, you have to be proportional. So he says this is not proportional. You can pick one way or another whether it is proportional or not. Then he says he traces the hijab right to 19(1)(a) and he says primarily in the case at hand, the question is not merely religious practice or identity, but also freedom of expression given to a citizen under 19(1). And my question then is, my notes here are, why can't I come dressed as a clown then? What's the problem? Then all bets are off, boss. So I don't want to my idea here is to just give you an impression of how things go. I'm not particularly dwelt on the judgment that upheld the ban or on the one that didn't, but just to give you an idea of the kind of mental gymnastics bullshit that goes on, because you don't actually come out and say the truth. So one side says, look, 19(1)(a) doesn't matter. You're in a college. College is a limited space. College has the power to make the rules. Follow the rule. End of story. If you want to now defeat this, then you have to have an ERP under 25. You can't establish an ERP under 25. Justice Dhulia says, no, 19(1)(a) is more than enough. You now, if you want to limit it, you have to have a rule of proportionality. The state turns around and says there's also 19(1)(g). Those who are running the institution will also have a right to administer the institution, and administration is a discretion solely vested in them because they understand the current circumstances best. And then he brings in liberty, fraternity, the general lecture bazi, Aman ki Asha lecture bazi, Ishka Cārvāka, all that crap. Nobody goes, whether it is on the legislative side or on the judicial side, into the core question of, will you allow regressive practices to walk into your colleges? Right? That is broadly any case on hijab that you have ever seen in the Indian context. Broadly, the contours of all their arguments have been covered.
Yeah, basically, I'm going to say the quiet thing out loud, and these are my views, not Nikhil. Islamism is rubbish. Islamism is regressive. Religions, anyway, are regressive. Religions on steroid, religions on their absolute pristine steroid level are garbage. And the beauty of secularism and modernity was that we only kept the easy, comfortable aspects of religion, which make life good, and we rejected the rest. The problem is different religions have different scale of problems and different situations mein aati hain. In the case of Islam, the Sith Lord problem is real. Either you send your schools to Sith Lord school children, or you don't educate them at all. It's a choice they
Right.
have to make. And I
Right.
think the state should brutally come down and have to force these things. I don't give
So
a shit.
if you're going
Sometimes
to go down
modernity
that
has to
path,
be forced.
if you're going to go down that path, then there's a 2930 problem, which really the court should have dealt with in TMFI. And basically, the argument, a wonderful argument, very succinctly made by Mr. Salve at that time, appearing for Union of India, which was sullied completely by Soli Sorabji, who deliberately stepped into the case as Attorney General of India, and because he has the right to audience in any case, and argue and cut against the center's own stand. But the argument was that, look, if you are providing secular education and you receive any benefit from the state, land, money, whatever, right? You can't impose religiosity. That would have hit.
Exactly.
That would have hit Saint Joseph's. That would have hit any.
I don't
Uh,
care. Any
exactly.
uga buga, any
Exactly.
uga buga
Exactly.
that they
Yeah.
believe in.
But it would
You
have
take state
cleaned up.
money, you
It would
can't
have
do it.
cleaned up your domain of secular education.
I am personally fed up of this bullshit, man. क्या है ये?
कुशल,
फिर मुझे नंगा जाना है स्कूल, मेरे को जाने दो. सब देखो
नहीं नहीं
मुझे
नहीं
नंगा.
कुशल, तेरे को तो कहीं पे भी नंगा नहीं जाना चाहिए. तेरे को तो बाथरूम में भी नंगा नहीं जाना चाहिए. बेचारे बाथरूम पे भी बुरा लगता है मेरे को. But what I'm getting to is, be grateful social media exists. Okay. Again, Amna had made this wonderful point, which I think she credited to Arsha Malik, who said that, look, because the internet has arrived, the real core problems with, and in that context, it was for Islam because it was dealing with hijab, the real core problems of Islamism can't be concealed anymore. This applies to Hinduism. This applies to many regressive Hindu practices. This applies to many Christian regressive practices. It can't be hidden anymore. It's all out there. It's all being talked about, right? And you can't pretend it is what it is not, right? So according arguments of dignity, like the classic Linda Stassor argument to hijab, I mean, one of the greatest displays of mental capture and derangement that I've ever seen was a great hijab march when Trump had first become president. Liberal white women sometimes go beyond the pale, bro. Like beyond the
Yeah,
pale.
it's the chickens for KFC movement.
Yeah, chickens for KFC movement is what it was. But at least in countries like America, because they're so discursive, I think it'll bounce back. They always do bounce back, and they did to a large degree bounce back. But in India, we can have pockets where there is no debate. It's still dark. The internet, though, gives some light. So DMA Pi is being decided in 2003, 2004, Islamia in 2008, 2009 onwards, right? And forget the names, right? But the core of it is minority institutions are placed at this pinnacle. Like इनको तो छू ही नहीं सकते आप. इन्होंने जो करना करे, right? Today, that argument, very simple argument. If you get benefits from the state, right, and you provide secular education, you cannot have religiosity every. You cannot restrict admission to just your community. You cannot give benefits to your community beyond the benefits that you give to everybody. You have to basically be equal. You have to basically be equal. Otherwise, be a Bible school or be a Quranic school, a madrasa, no problem. But your degrees will then not be recognized in the same way in which a secular schools recognize. ये scam बना के रखा हुआ था बहुत देर तक. Assam ने, just look at what Assam did slowly. It took out all these recognitions that were given to madrasa. They're teaching you nothing, but they are being recognized. The degrees being recognized at par with, say, a DPS Guwahati. Right? So that scam was being undone by Hemanta Biswa Sharma. So, the right has umpteen problems, but some of the right's truths have to be accepted. The left has umpteen problems. Some of the left's truths have to be accepted. The right's truths tend to be on religiosity, and they are able to see it clearer. The left's truths tend to be very good on feminism, and they tend to see that clearer. You have to meld the two. You have to meld it. That's what any responsible government would do. And I think almost every Indian government has done it. You may frame it whichever way you want, but all Indian governments have done it, including Modi's government, Prime Minister Modi's government. So, this is where I think sort of you have to have that understanding of what is good. It's a very practical thing, boss. You can't get lost in philosophies on all of this. It's a very practical thing. A tilak or a vibhuti is not at parity with the restrictiveness of a hijab, especially given the volume of literature we've seen on it, the kind of movements we've seen on it in Central Asia and everywhere else where this is enforced, and more importantly, the kind of violence that follows both against women and against other non-Muslim communities when these kinds of symbols start appearing in communities where they have not existed earlier. You're seeing this in Europe as well. That is why European Parliament, I mean UK Parliament in particular, and Australian Parliament had this argument, had this debate recently, but were not even allowed the debate. The right was not allowed the debate because the left, through one of its proper hissy fits, wouldn't allow the question to come up in a proper way.
Yeah.
Right. So, you can't escape these truths. I mean, 10 years ago, when right-wing accounts in Europe used to talk about how there's an immigration problem coming, they used to all just be dismissed as bigots. Now the left-wing parties everywhere in Europe, they have now internalized the softest part of that right-wing agenda. Right. So today, for example, Keir Starmer's government is crystal clear that they're going to impose very strict restrictions on immigration. What used to be a core Tory agenda and is completely opposite to the agenda on which he ran.
It's happening in
So
Canada too, right? All the
that's
immigration
right.
restrictions are
Has
being
to happen.
by the
Has to
liberals.
happen. Cultural preservation is not bigotry. Provided you are open, that culture is an open culture, that culture is dealing with liberty as its core formulation. This is literally how you think about all of this. There's no other way to think about it. Right? Then you can make a look. If I've read to you Supreme Court and High Court judges, they're creating word salads. We can also create these word salads. But eventually you have to be clear about karna kya.
No, I think, you know what, before we conclude, I just want to say this. Eventually, Indian society and Indian liberals, especially, and the Indian left, have to realize that bad practices are bad practices. Two, three things. You have to stop looking at this. If you are an individual, then there is no minority majority. If everybody is an individual, and secularization literally means in certain realms there are universal principles that you have to follow. And if you are incapable, like I believe this is going to be with slaughter laws also. I think you should have secular slaughter rules and slaughter
Yeah,
laws eventually.
absolutely. You
There,
have to
there are
look.
certain areas.
You have to have practicality, boss. You have to accept that there is a
Yeah.
large part of
And
your population that consumes beef. What's the problem?
yeah, and where a lot
You
of these
can't
things
limit
have
them.
to, you have to come down in a multi-religious, multi-ethnic, multicultural society. There is going to be a give and take on some issues. And also, I don't care if Muslim sentiments get hurt sometimes, Hindu sentiment gets hurt sometimes. In some areas you will have to do it. And um
Pick the good
this
things.
my
Yeah, pick the good things from everyone.
yeah,
Pick the good things
yeah.
and do it.
And I don't
And
believe in that.
mostly, by the way,
I don't
it's
want
not
to
even
impose
picking the good things.
atheistic principles on people. I genuinely believe that religion is something at its core worth saving, because what I saw in America after the fall of religion is even more scarier than religion.
No,
So I don't
but
want.
Kushal, a lot of that is naturally in the personal domain. That's not the stuff that gets expressed, right? That's for example your piety towards, or your devotion towards not just gods, but it brings the devotion towards, say, elders in the family, etc. This stuff's not on battle, right? This stuff's not being battled on. The stuff that's
Yeah.
being battled on is very easy to pick out. Otherwise, religion is secure, and perhaps therefore the ERP is not a bad idea because it protects that core. Let the core be protected, but beyond that, let's make sensible laws. As simple as that.
Yeah. Yeah. Anyways, I
Yeah,
just find this,
to
a
the
it's
Indian
a
left in general, I am crystal clear on this. You are 100% in the wrong on the hijab debate, as you were 100% in the wrong on Babri Masjid.
yeah. It's ridiculous, and I just don't understand. Like, I think Islamism just broke the back of liberalism and leftism. They just don't know what to do. They don't know what to do. Anyways, chal yaar, we'll wrap up.
No
But
questions?
क्वेश्चन दो तीन थे, वो मैंने तेरे को ऑलरेडी पूछ लिए बीच बीच में.
आज ठीक.
मैं तेरे को जो क्वेश्चंस उन्हें पूछे थे ना, मैंने तेरे को ऑलरेडी पूछ लिए थे. आई वाज रीडिंग द चैट
And
एंड
I
एडेड.
assume it's a Sunday evening. Yeah, people have better shit to do than listen to
नो
me
नो
talk about this crap.
भाई, 1200 लोग इस समय लाइव देख रहे हैं.
कमाल है यार.
बहुत वेले
कमाल
लोग
है.
हैं. बहुत
No,
वेले लोग.
that shows they want to learn. Yeah. They want to really learn and see and understand what it is. It's very good.
Yeah. So that's what I was reading what they were saying, and I was asking their questions in between Vesebi and incorporating them. But you see, these are, like I said, these are fundamental philosophical problems that our society, our judiciary, our politics runs on only one principle: mitti pao. They do short termism, and every time there is a problem, they just say, "Arey mitti pao, aage badho."
Yeah, but be clear about certain things, Kushal. The Mitti Pow types were much more 20 years ago. They're becoming more specific in their rejection of this shit now. So 20 years later, it'll be even more sharpened. It'll be better. And like I said, thank God the internet exists for this reason. These arguments are going to get better, in my opinion. I know the sense of divisiveness that X often feels like it creates, but I do believe knowledge seeps down.
Yeah. Arey, you won't believe it. Like, I'll tell you, I did this monologue because I was, तेको याद है मैं तेको फोन पे भी बोल रहा था, I was just laughing and on that whole privacy. अरे संचार साथी, आप तुमने हमारी प्राइवेसी ले ली ना. I was like, यार मतलब इस देश में किस किस्म के चमन है, उनको मालूम ही नहीं है.
That one you have to have more open. Listen, okay, so the Chinese and the American companies have my data. I get it, and they're able to see everything. But brother, they're not capable of arresting me. The Indian state is capable of arresting me.
Indian state is going to arrest you using that Chinese and American data app.
That's what I'm
Screw
trying
the
to say.
संचार साथी app.
If giving
So
them
तुम्हारा
access is
कंसर्न
scary.
संचार साथी नहीं है, और जो उसके पहले वाला वो सब नहीं है.
Yeah, but giving them access is a scarier thing than
अबे
another
घंटा वो
example.
कुछ एक्सेस है, वो ऐप. अभी अभी मैं ये ईमेल रीड करने वाला हूँ. ओके, I normally don't do these things, but read. See, that these kind of people do listen to me, so I found it very interesting. So ये मुझे, I'm not going to disclose the name. Hi Kushal, I have listened to your podcast on Sanchar Sathi app. I agree with the argument of privacy that in today's world it is a myth. You also quoted this app as a waste of money or non-government business. क्योंकि मैंने इस ऐप को criticize किया था. I'm writing this mail just to take your focus from money accounting to national security. As a member of the team who developed this app, anonymous email आया, उसने अपना नाम disclose नहीं किया है मेरे को. This is the person who built the app, for some odd reason was watching me and sent me this email. ठीक है. We need this app in every phone. I'm just placing his point of view or her point of view for the principle of fairness. It is crucial for our police and investigating agencies. When we initially introduced the verification of SIM on user documents, we were able to delete around 1 crore, ज़्यादा नहीं, 1 crore SIM from the market at that time. Then we merged some data with another project that we were doing. I found out more than 15,000 numbers were issued using the same IDs or fraud IDs with the same Aadhaar numbers, which were becoming a headache for our investigating agencies. These little projects can change a whole lot of things in terms of digital protection from now on, but they aren't very profitable, so any private company picks them up. These projects don't cost much, but help a whole lot. Thanking you for not having views like we are some hawks over people. We just want to protect. It's clearly somebody from inside the system watched this and sent me this email. We just want to protect digital identities, and we also understand the brutalness of our bureaucracy that can make things difficult for someone. But this app is just for the benefit of our people. It doesn't have anything that can be misused. मैंने एक लाइन का mail जवाब भेजा. Thank you for reaching out. I'm more than happy to be educated about it. So if you can share and educate me, quote bracket में, with actual verifiable evidence, I will change my mind that this app is not a waste of
The
money.
day this app arrives, there'll be a Supreme Court challenge. That email will be the judgment. You take it from me. That email will be the justification for why the app survives. Puttu Swami and privacy will be all out the window. This email will win it.
So essentially, which is what I said, ki the day I realized what Pakistan, China do to us, I'm sorry, मेरे अंदर का libertarian उसी दिन मर गया. Everybody can go to hell.
You know what? I've been going through the same thing. The shit that we've seen going on in our borders over the last year and a half, right, has made me go like, man, you can't play games in this region. You can't be theoretical in
You
this
can't.
region.
So, ये ना तुम्हारा
The
neighbor
games at
Canada नहीं
different
है.
level. They're at a different zone. National security is actually that imperative for us.
तुम्हारा neighbor Canada नहीं है, तो ये जो ये ना I am a libertarian, मैं ऐसी libertarian बातें करूंगा, ये अपने पिछवाड़े में डाल लो अगर तुम्हारा neighbor Canada है. तो यहाँ पे neighbor पाकिस्तान और चीन है और बांग्लादेश है. So मतलब it's ridiculous to have these expectations. The line should have been, मजे की बात है इस देश में किसी को 295 एज चुभाता नहीं है, मगर उनको संचार साथी क्या देश है. मेरे को तो हंसी आती है. Anyways, चलो, I don't want to waste anybody's time, but this was, तूने मेरे को इतना वो गंदे गंदे कोट पढ़ के ना फिर से तूने मेरा दिल जलाया है. जो कमीने, तूने मेरा दिल जलाया है वो.
Look at the quality of judgments I gave you. One guy is coming and saying,
डिप्रेशन हो जाती है
I
मेरे
have
को.
4 wives. I have to have one child with each wife. The other guy is coming and saying, my wife can't be on an electoral roll without a parda, which means he's going to have, I don't know, lakhs of photographs on an electoral roll with just a burqa. Fantastic stuff, yeah. And courts have to decide this shit, dude.
कोर्ट्स का भी मन करता है ऐसे चप्पल ना फेंकू इसके ऊपर.
This comes to you and you have to go like, अब यार नोटिस इशू करो, वो जवाब दायर करेगा, 10 तो एडजर्नमेंट होगी जी, मेरा काउंसिल नहीं है, ये नहीं है, वो नहीं है, बकवास चलेगी थोड़ी देर के लिए, उसके बाद इवेंचुअली जजमेंट तो वही आनी है कि ये, I mean, this is so commonsensical. This shit has to be out the window on day one, right? But courts don't actually operate like that, and that's why it gets clogged.
Yeah. Chalo, we'll wrap up there, guys. Go follow Nikhil on X. All the details are there in the description. And as always, if you want to support the Cārvāka podcast, please consider joining the membership program. All the details of how you can support the Cārvāka podcast are there in the description of the podcast. Like this video, subscribe to the Cārvāka podcast YouTube channel too. And if you're an audio listener, leave a rating on your preferred audio platform. I'll see you guys next time. Until then, it's goodbye from Nikhil and I. Bye.